afternoon, everyone, and welcome to our October Beat Bite session. Change is constant, managing alterations and modifications in your community. I am attorney Melissa Francis, an associate here at Zelmanski, Danner, and Fiorito. Today's presenters are Edward J. Zelmanski, a partner at our firm. He has been practicing law for over 40 years, and for the majority of his career, he has been practicing in the realm of condominium and homeowners association. Ed brings a cornucopia of knowledge and firsthand experience to the table today. Ed is joined today by our associate Richard Wagner Jr., who has also almost a century of experience, and Richard adds to the already overflowing cornucopia. I will be your host on Zoom today. If you have any questions, please put those questions in the chat and I will get them to our presenters. If you're joining us on Facebook today, please put your questions in the comments and Ms. Marsha Williams, who is our moderator on Facebook, will ask those questions for you. If you would like a copy of today's presentation, you can email me at mfrancis@zdfattorneys.com. If you do not already have your video off, please turn your video off and please remain muted throughout the session as we are recording. So today we are going to be discussing alterations and modifications in condominium and homeowners association communities. And we will be discussing the following 6 topics. 1, why is uniformity important in condominium and homeowners associations? 2, what are the mechanisms for controlling uniformity in your community? 3, what are definitions that are associated with alterations and modifications, and what are the risks of allowing alterations and modifications? 4, what procedures are best for your community to use for alterations and modifications? 5, what are the statutory considerations that you should keep in mind when approving or rejecting an alteration or modification request? And 6, what are the damages that could be imposed should you fail to approve an alteration or modification in certain circumstances? So our first topic will be covered by Ed, and I will turn that slide to him.
Well, good afternoon, everybody. I think Melissa said something about 100 years of legal experience, and I did the math, and I'm at 43 years, so I guess Richard has to round us out to get us up to 100, and I think he does.
Close.
But this keeps us young, as you can see, so that's why we enjoy doing it. Uniformity in a condominium or an HOA. Certainly we're familiar with condominiums that all look the same. They're joined units, apartment style, and you may have units constructed of like materials with a limited number of styles and colors. We want to have consistency in terms of maintaining the relative percentages of value among the different units. If people start changing their unit, it may start to look prettier than the neighbors. And we also want to be sure that equality is honored amongst the co-owners with regard to uniformity. So owners in association have a predictability and assurance in the appearance of the development and help maintain the values of their units. They're less likely to suddenly face their neighbor's home being painted purple or units not being maintained. And I think you can really, at a glance, you can take a look at a community and be able to tell whether absolute uniformity was prized when the development was set up. More likely to be the case when you have attached unit condominiums, apartment style or townhouse style, that sort of thing. You're going to see much more similarity and uniformity. And then if you get into site condominiums or individual lots in a homeowners association, you may see that uniformity diminished because everybody's house or unit might be allowed to look as the co-owner or owner would like it to look. Although certainly there can be cases in HOAs where the HOA has color standards, material standards. And again, those are there to help protect values, keep market values high. I think recognize that if a community appears as though it was set up with uniformity being highly prized, like apartment style units, and that uniformity is not maintained or protected by the community may look a little dog-eared, and that I think will reflect in market values. So if the community was designed with high uniformity in mind, maintaining that uniformity is going to be part of maintaining property values. Some of the studies show that uniformity in color influences our mental state. I guess that could be good or bad, eh? But the importance of the psychophysiological effects of color, the relationship between visual ergonomics, design, and color placement that provides the best site conditions for locating specifics and using the environment comfortably and color comfortably are part of how an environment influences the well-being of residents. So if you have a nice color palette that is maintained there and respected, then that's good for the mental well-being of the members of the community. Again, as I mentioned, property values are influenced by the appearance of the community. Uniformity and consistency and high standards helps keep property values higher. If it appears that properties were to appear uniform, but you've kind of fallen off the wagon in terms of enforcement or observation of standards, then a community looks a little tired and dog-eared, and that's going to be reflected in lower property values for a community that doesn't maintain uniformity. Okay. Now, so that's why uniformity is important. What mechanisms do we have for controlling uniformity in your community? Well, the association governing documents are going to be the key to establishing the standards of uniformity within a community. That might be the master deed for a condominium, a declaration of covenants and restrictions in an HOA, bylaws in both condos and HOAs, same with rules and regulations, policies, and procedures. So with regard to uniformity in a community, you look to the master deed in a condominium and look to the bylaws to see what restrictions have been established in the documents for that community with regard to expectations for establishing uniformity and maintaining uniformity. Same thing would be true with declaration of covenants and restrictions in an HOA, where some of those declarations, the restrictions in them can be pretty detailed and restrictive. So again, you need to know what's in those governing documents in terms of, how have the requirements for maintaining or establishing and maintaining uniformity been established in the documents. Thereafter, once we look at those kind of bedrock documents listed in A, B, and C, then we get to rules and regulations in D, or policies and procedures that, generally speaking, are going to be established by the boards of directors in the different communities. These are kind of the procedures or tools that a governing board and association has at its disposal to deal with the everyday things that come up. Could be that the master deed says everything looks like this. But then we talk about the topic of the discussion is that change is constant. And so people are looking at uniformity and perhaps rebelling against it or wanting to modify it to suit their individual taste. Or they just run renegade and do their own thing. So rules and regulations, policies and procedures are established in the community to say, these are the expectations that we have developed in this community. You should know what they are and know that you are governed by them. So what do association governing documents do? Establish expectations for behavior with an accepted norm and provide for maintaining property values. Provide the association's board of directors with the ability to enforce the terms of the documents and govern their community. Some association documents establish an architectural control committee separate from the board of directors to oversee the appearance of the community, or other forms of committees to oversee and make recommendations to the board of directors. I think an architectural control committee, you're typically going to see that sort of committee established in the governing documents by the developer at the upfront and building end of the community. The developer will appoint himself as the architectural control committee while he's busy building units. And oftentimes, there's provision for that architectural control committee to be continued by the association's governing board when the association takes over the governance from the developer. That's something you need to watch for when you're looking at your documents, because sometimes it may be that architectural control is established and a lot of detail is included in your documents about how that's to function and what the board is empowered to do or the committee is empowered to do. And oftentimes it may be the case that architectural control has to be specifically handed over to the community by way of a written document from the developer saying, I pass architectural control over to the association, with a requirement that that assignment of that power be recorded with the Register of Deeds. It's always we need to make sure when you're looking at your governing documents that you know the limits of the board's governing authority, and that you respect that if the documents require that a document be signed by the developer to give the board that power, that you take those steps. A lot of times, I think when a development, the buildings are almost all done, everything's being wrapped up, the developer's getting ready to move to South Carolina. What happens is this gets overlooked. So the community takes over governing itself. Nobody bothered to really look at the fine points and the checklist of what happens when the developer is leaving, to make sure that you get a hold of the developer and say, sign a document, turn over control of these things to us. So that's something, in terms of dotting I's and crossing T's, you need to be aware of. And I'll turn over the presentation to Richard.
Okay, thank you, Ed. That was excellent. Good afternoon to everyone that's attending. Those were excellent points. And now in the first two parts, we try to proceed in this in a logical fashion in terms of the importance of why we have consistent standards and so on and so forth, and they're implemented or enforced by reason of the documents that you have. So now what we're looking at is what happens when you get a request for an accommodation or modification, and you're kind of going outside the boundaries of the standards that have been set forth in these governing documents. And accommodations and modifications, we've touched upon this subject several times in previous beats. So basically, we've only sort of mentioned it in passing or given a little bit of explanation. Ed did a previous one, and I did one too in my civil rights part 2. So, but today what we wanted to do was get down to a much more definitive explanation of the interaction between the existing documents and when you receive these accommodations and modification requests. And what's important for you to know is basically what are the definitions and the risks involved with it. I've seen a lot of change in the last 30 some years, and probably Ed has too. You can address this when I kind of conclude my remarks, but there was a feeling for quite a while about why does this person deserve any special privileges? Why do they get that parking space by the front door? You know, just because, why should they get that? And a lot of boards were historically prone to just say, well, no, we're not gonna deal with that. Well, that's not gonna happen. Well, these are not just special people. They are people with some kind of physical or psychological problem that's resulted in the fact that they cannot conform necessarily, either physically or mentally, to the standards that have been set forth in the governing documents. And some people need actual help to be able to maneuver in life and live their life and enjoy their life in their community, whether they're born with a disability or whether they have acquired the disability by some form of defect or accident or serving in the armed forces. Either way, these people need some assistance, whether it be cutting in the curbs or wider doorways, or modifying their unit or modifying the access to the unit, or their parking spaces, or their walls or cupboards or whatever. And that's why the government has taken upon itself to say that these are really medical aids. They're not particularly handouts. They're not particularly special privileges. They're medical aids to assist people that have a need to go outside the boundaries, if you will, of the guidelines by the governing documents. I think, though, in the last 10 years, the pendulum has swung a little bit. Everybody's heard that, you have to grant an accommodation because they've got an official certification from internet service on their dog, or a doctor that they may have contacted once by Google or by internet, and like, well, we better do something or else. So they're kind of leaning towards, well, we're probably going to have to grant an accommodation or modification. And in that regard, we thought it was important to bring to your attention that's not necessarily true. So it's important for you to understand what these definitions are and what they mean and how they need to be applied in terms of making a determination whether or not an accommodation or a modification request should be granted or denied. An accommodation, the definition basically is, well, let's start with disability. Sorry about that. It's defined as a physical or mental impairment, physiological or psychological one, that substantially limits one or more major life activities, walking, breathing, 5 senses, so on and so forth. Virtually anything you do as a human being is subject to these considerations. There's a difference being, though, California always being somewhat different. They don't say substantial, they say it's significant. The changes, I don't know, anything could be significant. But basically how mostly the federal government looks at it is substantial. In other words, it's got to be something that has a problem that causes them not to be able to live their life in a normal fashion just as well as everyone else. So then you get to the two types of requests that are made. One is accommodation. Accommodation, and the reason why we bold these things is because these are the elements that you want to be looking for in terms of analyzing the request as to whether it's to be granted or not. It has to be reasonable. And it's an accommodation is a change, exception, or suspension or adjustment of the community documents. Now, I had just talked about, we got the master deed, we got the declaration, we got the bylaws. We're asking for a change or an exception for something like that, or a practice or procedure that's necessary because it's for a person with a disability to be able to have an equal opportunity to use and enjoy a dwelling or their premises, including public or common use areas. So those are important characteristics that you need to understand in terms of evaluating, an accommodation. Now, The reason why we bring this up is because of the fact that the risks of racial, religious, disability, and familial discrimination complaints have been on the rise since 2019. And more than half of these complaints are disability discriminations, with a substantial number of them being reasonable accommodation requests. Again, you look at the term reasonable accommodation requests. You might be hearing the most latest form of these accommodation requests has to do with things involving COVID and exemptions from requirements with reference to things because of they have a religious belief or a medical belief or so on and so forth. These are very tricky type circumstances that basically you have to understand that there's no one size fits all situation. There's no common answer. Every case is on a case by case basis and they're factually driven. And in that respect, it is important for you to understand these distinctions. Unless you want to move on to the next page, please. Now, an accommodation request must be made by someone or on behalf of someone. It could be, a neighbor, a friend, a relative, or it can be self-authenticating by the person who's requesting it. For a person with a disability or known to have a disability or has a record of such, or is regarding as having a psychological impairment that substantially limits one or more of their major life functions. Again, California is a little bit different. They talk about life functions and the general rule is life activities. All right. It can be in writing, but it doesn't need to be in writing. If the board becomes aware of something, then it's something that they need to take a look at as to whether some kind of action or some kind of relief needs to be afforded to an individual. You can't force them to fill out a form necessarily, but there is a basic form that, for example, we utilize in our practice in reference of trying to get the details. Like I said, it's fact driven and you want to know everything in order to have an objective orderly process or procedure for making the determination. So you can't necessarily ask what's the nature and extent of the disability, but you can ask a lot of questions with reference to what the problem is and what it is, why they're asking for what they want. It needs to be reasonable and reasonably related to the person's disability so as to enable them to utilize and enjoy their dwelling or the premises. And it needs to be done so that it can ameliorate or lessen the effects or impacts of the disability on their major life activity or function. You can't ask for one thing that has nothing to do with what their problem is. All right, that's not reasonable to begin with from the get-go. The request cannot impose undue financial or administrative burden on the community. There's a lot of federal cases that are back and forth on this. Some say both undue financial and administrative burden, or undue financial or administrative burden. I think the or version is more accepted because of the fact that it deals with different types of definitions. In other words, if it's going to cost the association an arm and a leg to do it, then that's not something the association necessarily has to do or be involved in to that degree. Also, the request cannot fundamentally alter the nature of the community operation. So, for example, the person says, I don't drive anymore, I'm older, I need you to get me bus service to take me up to Kroger's or whatever so I can do my grocery shopping. That's not, unless that's something that's part of your community operations, perhaps down in Florida at the retirement subdivisions. That's not something that you can request necessarily as an accommodation. The next page indicates you should always consider alternatives, item number 7. Now, there you go. Thank you. So don't look automatically to give an immediate answer or a reactionary denial or a reactionary approval until you've examined all the possibilities. There might be some mid-satisfactory resolution that basically accommodates what they want versus what they've really asked for. Is it something they need or is it something they wish they had? Okay. Your obligation is to accommodate things that they need in terms of the definitions. If it's doesn't fit in the terms of the definitions, then you don't have to grant it. And there's no penalty for denying it. But you need to be mindful of retaliation claims. Well, you can do it if you pay for this, or if you would do this, or if you would do that. That's going to be treated as retaliatory, and you're going to have a huge problem. Probably face substantial fines and attorney's fees. you're not allowed to impose costs on persons who are seeking to enforce their rights under the law, with some certain stated exceptions. All right, so the side note here is that a nuisance is not subjective. It needs to be an act or omission and not an isolated circumstance, but a perpetual circumstance that unreasonably interferes with the use, enjoyment, or rights of others. Frequently, you will get complaints about, well, someone is smoking down the hallway, or you hear the things about marijuana and so forth. Those are other beats that we have. But the thing being is, it has to be it can't be a subjective determination as that particular needs. You've got to have some objective criteria in terms of, is everybody complaining about it? Is this person just hypersensitive? And you need to examine how hypersensitive they are, or if that really is the case. Is there some supporting documentation? And then you make the decision on how to treat it or react to it. Again, FHA does not require you to grant an accommodation that would pose an undue burden or administrative burden or results in a fundamental alteration of its operations. There is a famous smoking case that's been around town here where reference to a person said they had physical reaction to smoking of the people upstairs, down the hall, and so on and so forth. Well, smoking is not particularly illegal in that community, nor is it illegal by law. So they had to look at the fact of whether their accommodation was reasonable to request that the board of directors ban smoking or ban these people from smoking anyways. Well, you can't ban a particular individual, you'd have to make it uniform. The association even tried to change the documents to say, okay, we're going to be a non-smoking community. That did not pass accordingly in terms of the restrictions and their amendments. And accordingly, the court found that the request to have this person request that everybody in that building not smoke was unreasonable, and their litigation was dismissed. We're going to contrast that right now with what's called a modification. Now, typically, a modification applies to the structures and the premises, as opposed to the accommodation, which is something typically for the person, the individual person who has a disability or a need to have an exemption or not be held accountable for bylaws violations by reason of their disability or whatever their mental or physical problem is. It's a structural change to the existing premises, the dwelling area, that's going to be occupied by a person with a disability in order to afford that person full use and enjoyment of the premises. It could be on the interior or the exterior and or common to public use areas. But again, the same standard applies here. It must be reasonable. You can't ask for something that that is ultimately unreasonable because it's too expensive or changes the operation of the community and so on and so forth. Generally, the installation and maintenance of the modifications request is at the expense of the requester. We get this request all the time from the board of directors. Well, they want, they want a ramp put in or they want this put in. Do we have to do it? Well, no, basically the federal government said if it's a modification that they want, they were going to absorb the expense and they're going to maintain it because it's a modification that they've requested, unless it's for the part of a common area for which the association is responsible. So, for example, if your association regularly salts and shovels the sidewalks going to the entry of the unit, and they need a handicap ramp, with reference to be able to get their wheelchair or their walker or whatever into their unit, then if you take care of the sidewalks, you're going to need to take care of that ramp in terms of doing the salting and snow removal. So there are times when the association does have to get involved in terms of the maintenance. But you need to know that the requester, they only need to show that the requester has a disability and that the request is reasonably necessary to assist the requester, because that is statutorily protected. In that regard, are there any questions on any of this so far, Melissa? Anyone? Okay, we like to kind of ask as we kind of go along.
Yep, we do have two questions.
Why don't we go ahead with that real quick?
Okay. The first question is, do you need to have an accommodation allowed to remain after the need no longer exists? So if the person with the disability is no longer present because they moved or for other circumstances, can you force the homeowner to remove the accommodation because it's no longer needed?
You want to do that, or you want to do it, or what do you want to do here? Can you hear me? I lost my video. Basically, one of the things too that in some of the cases what I've seen is when you do your interactive process and make requests of the health professionals, you ask whether or not it's a condition that's going to exist more than 6 months. If it's just a temporary situation, then you don't have to necessarily approve a major accommodation that's going to make it difficult for the community or other residents and occupants in the building and so forth. Basically, when they move, they need to remove whatever they've done unless the person acquiring the unit also has a similar need. In which case the changes to the community, let's see if I can get this back on, the changes to the community are also required by that person. Frequently, there's a request for, as people get older, they have people that come in to help them, and sometimes the people that come in to reside with them or tend to them have a request for special considerations for them to be able to assist the person who needs the help. That's another format in terms of it's something that you need to closely examine, because you may be required to allow an accommodation or modification for the person who's there to help the person who has a disability. So is there something you want to add to that, Ed?
No, I think you've covered it very well, Richard.
All right.
And then the other question is that in an HOA, if there is one resident who's wheelchair bound, must the association alter every curb to a sidewalk ramp so that that person can travel around the community?
That's a really good question. Basically, the things about curbs and stuff like that is more relates to the fact of whether the ADA applies. Typically, the ADA does not apply to a private community. It applies to public facilities whereby you are required to make those types of modifications. However, an ADA can apply to a community if the community is involved and makes their premises open to the general public. In other words, you kind of rent out your clubhouse or you rent out your swimming pool and so on and so forth. Then or you've got rentals that exceed 30 days and so on and forth. The ADA may apply, in which case those types of modifications may need to be done. But as a general rule, though, other than curbs for purposes of access to the unit, I don't see it being necessarily required for every single curb in there. Although, candidly, it's not a bad idea. You've got more than just people with disabilities. You got kids on bikes and everything else. If you want them to be on the sidewalk, you don't want them falling off over curbs. But again, it's a fact-driven situation. You got to look at what they're requesting and how reasonable is it? Is it reasonable? How many curbs do you have? Do you have to do every single curb in the community? I think most courts are going to say, no, you don't have to. Maybe around the building area where they are, and they might say, well, that's reasonable from, the parking spaces to their unit, or, around the corner to the back side of their building. I don't know. Ed, thoughts?
It's that I agree, those kind of considerations relate to the Americans with Disabilities Act, the ADA, those kind of curbs and sidewalk things. And so that's a whole different body of law. And that ADA generally is addressing public facilities or somebody who's in the stream of commerce, like a store who invites the public in. So in a closed down, tight, private community with private streets and sidewalks, ADA isn't going to be a factor. I was just wondering, Richard, when we talk about okay, the need to grant request for reasonable accommodation by a person with disability. Let's say that person is wheelchair bound. You're saying, well, you know, and I agree that I don't know that they could pose a reasonable request to knock down every curb and on every sidewalk within the community. I was thinking, though, if, for example, there were walking paths that are part of the community, and community developers often like to include walking paths in the development. And so a person in a wheelchair says, you know, the walking path needs to be wheelchair friendly. So as a person with a disability, I can enjoy the walking path as much as every other able-bodied person. That would be kind of a stretch of that concept, and it would have to, I think, be where there was a, you know, a discrete amenity like a walking path that was offered for the use of everybody. Then would it be reasonable to say that, you know, the association has a duty to make the walking path accessible for a wheelchair bound person? No, what do you think, Richard?
You know, I've seen that. I've seen where there's walking paths where they use like wood chips, you know, because you want to be in a nature trail, things like that. I think there's going to be a lot of factors to be taken into consideration. For example, even the size of the community, the size of their budget, although money is not everything, the fact remains is, you know, if their annual budget is a certain thing and it's going to cost them $100,000 to pave it, and you take into consideration that you change the wood chip situation into asphalt or concrete, aren't you in fact basically taking away some of the you know, the aesthetic value of the walking, you know, through the nature trail? I would think if here would be a situation where you might want to propose a reasonable alternative is if they've got an area, a paved off area or a certain portion of it that they can say, okay, you know, this is an area that's available. It doesn't cover the whole trail, but it does cover part of the trail if they want to be able to do that. I guess I think would be an alternative attempt at a reasonable accommodation or modification.
Yeah, and that, you know, yeah, that goes into the reasonableness of the request.
Yeah.
You know, as you know, the impact would be broader, I think. It's like, well, okay, and you know, that is beginning to test the bounds of reasonability. Although I like your example of, okay, maybe you have a smaller portion of walking paths that are wheelchair friendly, that sort of thing. I guess I'd say, and part of it might be how much in terms of community resources are invested in that. So if I'm a member of the community wheelchair bound and we're spending a lot of money in the community on those amenities, then my inability to share in the use is perhaps more marked. But I think what this discussion just emphasizes is, as Richard has said, you know, when you look at these requests, look at the details, slow down, examine all the factors that may be involved or may impact on this particular request. And in doing that, I think, you know, you are more assured that you'll come up with a reasonable compromise by way of what the association is willing to do, and that compromise would be deemed reasonable.
I agree. I do. I think, like I said, it's fact driven, and you have to look at a lot of different variables. Okay, we kind of run over on our time here, so we're going to cruise through some of this. What procedures can be used for alterations and modifications in the uniform community? Generally, most of you are probably familiar with the fact that you have a form. You got an alteration modification request form. You want a detailed description of it, drawing and engineering reports if applicable, the name of the contractor, insurance available. You know, and not only that, you want to make sure they have general liability, workers' comp, vehicle insurance for their vehicles on the premises, so on and so forth. Acknowledgement that the co-owner that the work cannot be perform until there's written board approval has been received. The association board or the architectural committee reviews the requested alteration and makes, and sometimes make the decision, or sometimes they make a recommendation to the board. Typically what will happen though is they'll make a recommendation, or if they make the decision, it could be appealable to the board, or they'll make a recommendation to the board. So the recording of an approved alteration modification with County Register of Deeds, that is a form that we have available, we've utilized frequently. Going back to the earlier question about what happens when they move and everything else, you have to consider all these costs. You have the right to utilize this modification or this accommodation until such time as you no longer own the unit, or you move out, or so on and so forth. Restoration needs to be done to the extent required by law, and paying appropriate costs to set it aside. So who should approve costs for alterations, modifications, and being recorded? Again, if it's something that's requested by someone, I think that's involved. I think how FHA treats it and the MDCR, Department of Civil Rights, is if it's something that you would require of everyone, you're not really penalizing the person for making the request. In other words, if a request was made for an alteration or modification by someone who's doesn't have a disability and they're required to pay for it, you're not discriminating against them because you require the person who has a disability to do it. So I think that's an important consideration. And in that regard, the cost is passed on. You want to make sure that you have in your minutes the consent forms and the memorialization, the exact nature of what's been approved, why, for when. I mean, you don't have to describe, well, this person has whatever disorder, but you can say, pursuant to law, we've considered the request for an accommodation or modification, and we've approved the following circumstances. That way the corporation is protected, the board members are protected for the fact trying to be accused of being arbitrary and capricious, because you've detailed it in the corporate records as to what's been requested and why you're granting it or denying it. Okay. All right. The last part of this section, I think, is timing in the interactive process. The interactive process, this is the next page now, sorry. Interactive process, we could actually spend a whole seminar on. We may do that someday, I don't know. The interactive process basically says, first of all, timing. You need to address all requests formally and promptly. Undue delay equals denial equals potential liability. You can't just, well, we'll get to it like a couple months. That's not going to happen. You're going to have real problems if you do that. A lot of cases say if you waited 30 or 60 days, you're liable automatically. And you'll see an example I'm giving later in this portion. The association and the person requesting accommodation must engage in what's called the interactive process. And the interactive process basically is they make a request. You have the right as an association to ask certain questions. What's the nature of the request? Is it reasonable? If you go back to those definitions, in terms of the accommodation, what is it that you're requesting? Is it reasonable? Is it something that's going to help you? Will it help ameliorate or diminish the impact of the disorder or disability that you have? So you have to process every single one of those things. Also, the fact of whether or not they have substantiation or authentication for the fact that they are a person with a disability. That's one of the first questions we ask to a healthcare professional, is whether or not they can attest to the fact that this is a person who qualifies as a person with disability under the Fair Housing Act. If they can't substantiate that, then obviously, the first leg of the puzzle is missing, right? But there's all kinds of them, and some things that the boards don't recognize the fact that even hoarding, you get a lot of us old timers that have a tendency to save everything. And as a consequence, you're involved in hoarding. And question is whether or not you have to tolerate the fact of the violation of the bylaw that says every person must keep their residence in their areas, their limited common elements of their yards in clean and sanitary living conditions. So you have to grant an accommodation, because hoarding is an official psychiatric disorder under the diagnostic, statistical, whatever, medical thing. It depends. Here we go again. It depends. You have to use the interactive process to try to come up with a solution. And maybe it's a matter of you getting relatives involved or getting senior services involved or something. So you're not going to sit there and issue tickets and issue fines and try to do all that kind of stuff, because what are you really accomplishing with that? It's not solving the problem. The problem is you've got the circumstance where you've got a number of a buildup of accumulation of items that needs to be gone, or else you got fire hazards, or the person could die in unsanitary living conditions. So that's why you need to use this interactive process. As an example, on the next page, no, the association's last minute accommodation. There's a situation where there was a tenant that was being harassed and threatened with eviction, more or less. The association told the co-owner, landlord, that this person has animals and they can't have animals. It's a no animal community, and so on and so forth. She got an attorney who basically sent a letter saying, no, she has letters from 2 different doctors. She does need this emotional support animal, and you need to allow. The community relented and said, okay, we understand, we're required by law to grant this accommodation, and so you can keep the dog. Fine. Well, the association thought, well, we granted the request, so now the lawsuit goes away, right? Wrong. Even though they granted the accommodation ultimately and allowed her to stay there with her dog, the court dismissed the portion that said she was treated unequally, but allowed her to continue her pursuit for claims with reference to the fact of she was threatened with an eviction, the threatening actions she had, and the harassment, the emotional experience, because of the fact that she had a disability. So you have to be careful. You have to get on these right away and start the process of asking the questions. There's a letter that we send out to the healthcare provider. We need to get a consent form for the person who has a disability to allow us to ask the information. We do ask the healthcare provider they don't need to tell us the nature and extent of the disorder, but they do have to answer those criteria that I've set forth in the definition. All right. So that being said, I think we can move on along to the statutory applications. That's Ed.
Well, as you can see here, we've listed a number of statutes that exist to protect the rights of persons with disabilities and put into play these various mechanisms that we've been discussing in the earlier part of this session. There is Michigan statutes that apply and federal statutes, and the protections overlap or kind of work together. Actually, the Michigan statute for persons with disabilities has a mandate to protect the federal rights that are granted in the Fair Housing Act. So we have a lot of law here. The Michigan Condominium Act deals specifically with the right of a person with disabilities to alter their unit to facilitate coming and going from their unit. Persons with Disabilities Civil Rights Act, like the federal laws, is established to recognize that persons with disabilities are assured the right to enjoy facilities like every other person who doesn't have a disability. I think Richard said, well, earlier, this is kind of new, it was earlier on and people didn't quite know what to make of it. But most assuredly, and Richard and I can attest to this, we're all getting older, a lot of baby boomers, and guess what? A lot of people are experiencing limitations because of the aging process. I suppose the one way to avoid that is to remain in perfect health or to die young. But I'll take the middle ground and recognize that there will be continuing increase in impact these statutes on how your communities operate, because persons with disabilities will have needs and will present them. In federal statutes, Fair Housing Act looks a lot like the Michigan Persons with Disabilities Civil Rights Act. And again, is there to assure people with disabilities will enjoy the same ability to use the facilities in a community and have a relaxation of restrictions and rules to enable them to enjoy that. There also can go beyond movement. For example, one case that I'm familiar with, a community had a restriction in terms of the type of curtains that could be displayed in the front wall window. And they wanted kind of shears curtains. And that was set up as a requirement in their bylaws. But a person that had a particular disability that included a serious sensitivity to light needed room darkening curtains to assure them that they could enjoy the use of their living room and not be exposed to an improper amount of light given their condition. So nothing was involved in that particular instance that would assure that person the right to come and go. However, their right to enjoy the use of the interior of their unit required that the association relax its restrictions on the type of curtains that were allowed. If you get outside of condos in a subdivision, you don't have the same kind of statutory involvement like you do in condominium communities. And again, ADA requirements are more likely to apply if you have a traditional subdivision with public streets and sidewalks. And really what it comes to mind is, I think if you look at what's on this page here, you will appreciate the seriousness and complexity of the duties that are established by these statutes. And that's why we urge you to move carefully and with due diligence when faced with any sort of request that might be protected by these statutes. Moving on. Damages.
Yeah, I think so. So basically what we want to impart on you, and I know this is maybe not the most favorite circumstance for most associations because you're a nonprofit, but you really need to get your attorney involved in these claims, because they're going to make the analysis and assist the board in making a determination. Now, you're going to be on site with reference to the facts, but at least your attorney can help you negotiate through the facts and the application of law to the extent that they can raise a defense. More and more you're going to see, and I can't tell you how many times I've seen it already. You only sent me that dog letter because of the fact I'm a blank. And fill in the blank. I don't care what it is. You can pick any subject in the world, and you get a complaint filed downtown, and you're off to the races. I mean, you're probably a couple of years without even ever seeing an administrative law judge. You spend $10,000 to $20,000 just because of a letter. So it's important that you get your attorney involved. It's also important that you get your documents amended to address these scenarios that the policy, the official policy of this community is to adhere to fair housing and civil rights regulations and so forth. So, but anyways, the fines from HUD are extremely stiff and costly. And you have to remember too, that such expenses are not necessarily covered by insurance, because statutory violations such as discrimination is not a negligent act. It's not a covered event or circumstance. So they may defend you, but they won't pay a judgment that's potentially awarded. And a lot of time that breaks down to the fact of going, okay, we got this case settled for this amount of money, so we're going to settle this case. And whether you have any capability to say, no, we don't want you to settle it, now it's going to be determined by your insurance policy. But nonetheless, they say, and you say, well, wait a minute, we didn't do anything wrong. We don't want to admit this. We don't want to settle this. And they say, well, you know what? then you're on your own. If there's a judgment awarded, you are basically on your own. Fines can be levied by HUD, extensive fines and dollar figures in the 6 digits for attorney's fees in terms of defending these kinds of actions. Michigan basically says there's no exemplary damages except part of compensatory damages, but compensatory damages includes damages for embarrassment, emotional distress, humiliation. So, I guess it's kind of like you say tomato, I say tomato. I don't know. Nonetheless, you have a high risk of exposure there. Although theoretically, technically, the actual damages should be proximately caused by the discriminatory conduct. And also, you've always got the circumstance where a plaintiff are supposed to mitigate the damages. But there can be, in the federal cases, punitive damages that can range from issues of maliciousness or willful misconduct, or even reckless disregard for another's right. Again, like the lady, the tenant, who was accommodated by letting her have the dog. The fact is, all the stress she went through about threatening eviction was very dramatic. And apparently they convinced the court of same, to the extent that the court was not willing to dismiss the case. As a consequence, their litigation could go on and on and on. So again, you get these, or when you become aware of them, when you become aware of acts of incivility, you do have a duty to step in and do something, whatever you can do, but you certainly got to investigate it. I don't know. You want to add some more on the damages, Ed? And I think we're wrapping this up.
Well, I think, sometimes people say, well, you're just trying to scare us with this stuff. And we're not offering this to scare you. We're telling you legally this is the potential consequence of failing to honor the rights of a person that's assured under federal and state law here. But also, I think what I wouldn't want you to walk away with would be to adopt or maintain an attitude that this is an adversary process, that it's like this person is out to take something from the community, and we don't want to give it to them. I think if you start with that mindset, then be careful, you're heading down the wrong path. Again, Richard had stressed in his discussion the idea of this interactive process. So keep that in mind. When a request comes in, it's the start of a discussion. It shouldn't be viewed as a demand. And I think with that mindset, you're going to really put yourself in a position to find reasonable and constructive solutions to problems that may be caused by this. But also just add that there are a number of cases that I've defended where the Department of Civil Rights has investigated a complaint that a person has made because of their alleged violation of these various statutes. And in almost all those cases, we're able to really fashion some sort of reasonable remedy that is agreeable to both sides, that doesn't end up putting the community in a real bad place, having to pay fines and everything. I haven't seen the Department of Civil Rights come in guns blazing, demanding that kind of relief. Oftentimes, a key component, what the department is looking for when a community has perhaps stumbled into a civil rights complaint being filed, is how open-minded is the community? How willing is it to acknowledge its responsibilities to honor these statutory requirements? And oftentimes, what goes a long way would be the agreement on the part of the board of directors to have some training on these things. And I've seen almost every settlement that I've reached has contained that element that, yeah, okay, we agree, we want to be well informed of our obligations. And so that goes a long way towards settling those things. So if you get a civil rights complaint, don't say, oh my God, this is going to cost us $100,000. It did not.
Absolutely agree. Good point, sir, Ed. I mean, absolutely agree. I've had the same experience. Usually, Department of Civil Rights, they'll send out we received a complaint. How do you want to respond to this? And you put together enough information to respond. But not only that, you make it clear to the department that you're willing to investigate and evaluate some kind of resolution that absolutely needs to be amicable. You got to remember that just though this person may have a disability or whatever, files a complaint, they still are a resident in your community, and it means a lot to have community cohesiveness. Um, you have to try to all live together under whatever circumstances each person faces, and that's why these are not one size fits all situations, and they're fact driven tremendously. So, with that, are there any other questions, Mel or Marcia?
Hello. I do not see any questions in our Zoom chat, and I am not sure if there are any Facebook questions, but I will give you a few seconds if you have some questions. If you'd like to type them in the chat box, I can ask our presenters. And while we wait for questions, I just want to let everyone know about the CAI Michigan Legislative Action Committee. The Legislative Action Committee was formed in 2002. It is one of many legislative action committees throughout the United States that's part of the Community Associations Institute. The Legislative Action Committee works with the Michigan legislature to develop laws that impact community associations and to provide input into laws that are being proposed by our Michigan legislators. They also work with the National Legislative Action Committee to provide feedback and to discuss the impact of proposed legislation nationally on community associations. The co-chair this year of the Legislative Action Committee is our very own partner, Gregory J. Fiorito. If you would like more information on the LAC, or if you'd like to make a donation to the LAC to assist in their mission, you can visit their website at www.cai.org/advocacy/LAC/pages/default.aspx. And it does not appear that we have any questions in our chat, and there are no questions on Facebook at this time. So I would like to thank you for spending your Wednesday afternoon lunch period with us. Again, if you would like a copy of this presentation, you can either put your email in the chat to me, or if you would like a copy later, you can email me at mfrancis@zdfattorneys.com. If you have questions later for Mr. Zelmanski, he can be reached in our Plymouth office at 734-459-0062 or by email at zelmanski@zdfattorneys.com. Any questions for Mr. Wagner should be directed to him in our Mount Clemens office at 586-465-1330, or you can reach him by email at rwagner@zdfattorneys.com. And I'd like to invite you to put November 17th at noon on your calendar to join us for our next Beat Bite session via Zoom or Facebook. And again, you can visit our website, www.zdfattorneys.com, or follow us on social media on Facebook, Instagram, Twitter, or YouTube. If you go to our YouTube page, which you can find the link on our website, you will find many of our past presentations. And if you would like copies of any of those presentations, feel free to contact me. I appreciate your time, and thank you again, and have a wonderful afternoon.